Testimony only. Right now I call on Chairman Powell to bring before the committee House Bill 279.
Thank you, Mr. Chairman. This particular bill has undergone several derivations since we originally talked. The original bill provided for a pay increase for Court of Appeals, Supreme Court, Superior Court, public defenders, and DAs, and it was a $12,000 across-the-board increase in the base pay of all of these different categories of the courts. And generally it was based on the fact that there was an identical bill that was passed in 2008 that passed both houses of the General Assembly, but was later vetoed by the governor. And except for a pay increase that the DAs received in 2005, the public defenders have never received a pay increase other than cost of living increase since the initial implementation of the public defender program, and the other appellate court and superior court judges had not received a pay increase since 1999. And so the original intention was to basically redo what had been vetoed in 2008. However, there were some issues that came up in the original subcommittee hearing. Mainly, I'll sort of give you the Reader's Digest condensed version of what we found out, but that except for the Court of Appeals and for the Supreme Court, which received no supplements, we have supplements ranging in the public defenders from $0 to $52,000 for the chief public defender. In the district attorneys, we had supplements ranging from $0 to $78,000. And in the superior courts, we had supplements ranging from $0 to, my published number is 66,000, but I think that it's probably around 80,000 with all the supplements. And so anyway, there was a concern that in trying to increase salaries for the folks that are not getting any supplements, that we may be overly compensating, and that's a matter of beauty is in the eye of the beholder. But there was a concern that it might be difficult to get this bill through if it was across the board for people who were making anywhere from $120,000 to $200,000. And so we went back to the drawing board, and I sort of want to give you an idea of where we are on this bill. We have now supplements to deal with. With the superior court judges, the district attorneys, and the public defenders, rather than an across-the-board pay increase, what we have come up with is a state supplement. Not an increase in the base pay, but a state supplement. In the case of superior court judges, in the amount of $30,000, and in the case of the public defenders and the district attorneys, it's a number of $15,000. And the state supplement will be netted against whatever local supplements are already being received. So in the case of a superior court judge that receives a $35,000 supplement or a $30,000 supplement, then there would be no state supplement. In a superior court judge that received a $15,000 local supplement, then he or she would also receive a $15,000 state supplement. And the same thing in the district attorneys and in the public defenders. I don't know that I can say that I'm absolutely convinced that this is the right thing to do, nor am I convinced that these are the right numbers. But where I was going with this was trying to get the lowest paid judges and district attorneys up to basically the average of what everybody's receiving, whether it's in Cobb or it's in South Georgia, that everybody at least be brought up to either the median or the average for the state. And so, for instance, in the Superior Court judges, that was somewhere around $150,000. I don't know that this is anything but a short-term solution. Eventually, we're going to have to deal with the issue because it makes it difficult to pass across-the-board pay raises as long as we've got that kind of disparity in the supplements. And I think that for the next legislative session, I think that part of our project ought to be is to look at local supplements, and let's see if we can find out some way to deal with those without making it so difficult to increase salaries across the board. But for those of you who've looked at the substitute that you have in front of you, it's a little bit more complicated than what we had originally proposed when we were doing across the board. But the state supplement, the other issue besides the local supplements that we had to face was that with both the district attorneys and the Superior Court judges, that there are so many local positions that are tied to those, and if we do across the board increases, then that automatically results in increases for a lot of other folks, whether it be magistrate court judges or juvenile court judges or state court judges or CASA directors or whomever it may be. And we did not want, without having some impact from local governments as to what kind of impact that would have on them, we did not want to inadvertently increase the cost to local governments by our increasing state court and our Superior Court and district attorney salaries. So anyway, the state supplement that is proposed in this bill will count for retirement for purposes of state retirement, and it will not count as salary for purposes of determining whether local salaries go up as a result of it. So it's considered a supplement when you look at the locals that may be tied to a Superior Court judge or a district attorney's salary, and it will be considered a salary for purposes of determining whether you compute retirement on it. So it is a salary is not a salary kind of situation. Ultimately, what I would like for us to do is I would like to increase the base pay at some point in time, and I think this is a start to it, to get to the median average that we've been talking about, and to and then deal with the issue of local supplements, whether we replace those with a state supplement or whether we cap them or whatever we do. And certainly that requires a lot more input and collaboration with everybody involved than something that you do in a 40-day legislative session. There is a new substitute that you do not have a copy of, but the only thing that is different in that substitute than the one that you've got in front of you is in the area of Superior Courts, public defenders, and district attorneys. It requires their council, Superior Court judges, the prosecuting attorneys council, and the organization that handles the public defenders to certify to the AOC or whoever writes the checks as to what the local supplements are, so that determination about netting out the local supplements, because what we have is just data that we have gathered, but we do not absolutely know what every circuit pays. And so we put a mechanism in the substitute to require that they gather that data before they start paying out the checks. Now, the final thing that has been put in this the version that y'all have and the most recent version is that for Superior Court judges, in addition to the state supplement, there is also a state supplement of $6,000 for any Superior Court judge who is presiding over an accountability court. And that was in recognition of the fact that accountability courts have become something that has benefited the state, has benefited the criminal justice system, and a lot of people have kept their regular caseloads in addition to preserve accountability courts, and this was a recognition of that extra effort went into that. So is this something for everybody? Maybe not. Is this something that I'm totally satisfied with? Probably not. Is this something I think gets us to where we need to be, or at least a step in the way that we need to be? I would suggest that it does. And with that, Mr. Chairman, I'd be happy to answer any questions.
Thank you, Mr. Chairman. For the purpose of the committee, could you give us the most recent LC number?
It's LC 296493S.
LC 296493S.
Yes, 6493S.
Okay. Okay. Very well. Any questions for the author of the bill? Chairman Willard.
Thank you. You're doing an outstanding job, Mr. Powell, trying to bring some parity to what's been a long-standing problem in my mind with how we're handling trial court judges' salaries. The one thing you talked about I wanted to get some clarity on, and that is you mentioned the supplements that will be paid from the state will carry with it the retirement benefits. So allocating what will be an amount for retirement will include salary and the supplements when that judge retires. Is that correct?
Yes, sir.
But it would not do so with what is being received by a local circuit, being the counties, which are paid directly to those judges. That would not be something recognized within the retirement system for the purpose of their retirement.
And I agree with you, Representative Williams, and I don't know what the answer is. I'll tell you what my idea is, which I've shared with some of the judges that I've talked to, is that whether we wind up with the state supplement raising the lowest paid judges to 150, which is what this proposes, or 155 or 160, any one of those I think would be good numbers. But once we get the lowest paid judges up to that so that everybody is making at least $160,000, then I think the next step would be that we then make that the base pay next year or the year after. We make that the base pay, and then we deal with the supplements, whether we cap them or whether we put a maximum amount, but therefore we don't run into the variations that we have now that have made doing anything for salaried folks. I mean, the Court of Appeals and Supreme Court were an easy task to deal with because they are not currently getting supplements, but these other positions are getting supplements, and it made it extremely difficult to determine what's fair.
Question for Ms. Travis, possibly from the chair. Is it possible And I certainly support you in that, Mr. Chairman, in your idea, and I hope that we can move forward on that as rapidly as next year. Is it possible through local legislation for those that are not impacted, that are making higher than what this bill calls for, is it permissible for local legislation to be able to move forward so that their supplements will be computed in their retirement or not? My assumption is you can't, but I don't know if this legislation is going to affect the local. Yeah. As I've understood the conversation there, and that is they're in the big but I don't know if that is a possibility. I don't know what we can do. I will talk to you offline on it later on. I have some other ideas, but I certainly concur. The chair failed to, and before excuse me, there's one other question. I absolutely agree with the author of this bill. I do deeply want to see a long-term solution to this issue. I was brought into this kind of late in the fight, and I want to see a better, a more focused, a fairer way of looking at all the packages of judicial compensation, as well as that of all of our attorneys that are working, not only the DAs and the public defenders, but those that work for the Attorney General's office and others. And I also fail to recognize some of our judges. I think Judge Melton's here, our DA Danny Porter, Chuck Bayhouse, and some other judges that are here present. I do deeply appreciate your service and what you do, but I do agree this is a short term.
Chairman Powell, I know it's been a struggle for you with this bill, and I appreciate all the work that you put into it. On the, just want to go back to the accountability course for just a second again. It's my understanding, okay, it's a $6,000 supplement for the accountability course.
That's correct.
And like in my case, in my district, if I have two judges and they kind of share the accountability court, how does that work out?
Well, there are, in statute, there are 3 divisions of accountability court. And so accountability court in this bill is defined as a judge who regularly presides over one of those 3 divisions is then an accountability court judge. So if I went in and filled in for you one day, that does not make me an accountability court judge. It's one that regularly presides, and all of these courts are approved, and they have to meet certain standards in order to be accountability courts under the code and under the auspices of what's being funded by CJCC. And not anybody can just go in and preside over an accountability court, because everybody that works in the accountability courts has to meet those standards and has to be trained.
I hate to open my mouth with a group of attorneys not being an attorney, this because this may sound a little bit naive, but
well, there's an easy solution to that. Don't.
And because I've got some other things I want to deal with you on, I guess I'm not going to respond to that. But is it probably a fair statement to say that this may be a motivator for having more people look at accountability courts, which is maybe I hate to use the word motivator, but I think it's a good thing because it fits into the long-range plan for what we're trying to do with criminal justice reform. Is that?
I think what it does is that it validates the state's commitment to accountability courts. I think that if you ask any of these judges who preside or who have been involved in accountability courts, they'll tell you that the amount of extra time that they're putting in it and the amount of training that they've had to undergo and the additional scrutiny and paperwork probably isn't even worth $6,000. It's more of a, and I think it sends the message that the state is committed to continuing this path of criminal justice reform, but I don't think anybody's going to jump into an accountability court and all that it entails for $6,000. But I think it does some positive reinforcement.
And I think that's the point I was trying to get. That does some positive reinforcement, and in actuality, the amount of money that may be saved in the recidivism rate and incarcerations, things like that. I hate to say $6,000 is a drop in the bucket, but it really is.
That would be accurate.
Thank you, sir.
Okay.
Thank you, Representative Rogers. Representative Coomer.
Thank you, Mr. Chairman. Chairman Powell, let me say thank you for your work on this bill. I know you have you've heard a lot of complaints and concerns and addressed a lot of issues. I think you've hit the nail on the head by really addressing a concern for needing to bring up the lowest paid judges in this state to a level that we can actually attract and retain good quality jurists, while also considering a need to avoid creating further disparity between the highest and the lowest paid Superior Court judges in the state. And I really appreciate that. And also by including a policy of really rewarding judges who are using the tools we've been giving them to use, and as a way of expressing our support for that continued use of those accountability court tools, and also addressing the DAs, the PDs, and the appellate court judges' pay. I think those were probably the easiest things that everybody agreed on. My question is, in the bill that you have, the draft that you have, is there anything in there that would limit the ability of local circuits, counties, to continue to give appropriate pay increases to their local judges, a local circuit pay, supplemental pay, going forward as they believe is necessary in a local
There's nothing that prevents that.
Thank you very much.
And are there more questions, Mr. Chairman? I do want to bring up one other point.
There are not.
Okay. I will tell you that the discussions that we had, any of you who were at the appropriations understand that Chairman England announced that the appropriation was based on a $25,000 state supplement for Superior Court judges, not the $30,000 that's contained in this bill. But what I'm going to tell you is that the money that's in the budget isn't going to match up this regardless, because of the fact that, this changes at $5,000. But what I have done here is I have made an effective date of this bill of January 1, which means that the full year appropriation that was included in the bill that was passed out of the House last Thursday is actually more than what it would take to fund this bill, because it's only for 6 months. And the reason that I funded this for 6 months was that, number one, I knew that I had gone in 45, but I also when we were doing across the board pay raises. But I'm not too sure that we need to increase the distance between them and the Superior Court judges. I don't know that they should track them. If you ask the district attorneys, they'll say that they should get paid the same thing that a Superior Court judge makes. But I don't know that we need to increase the distance between those two. And I'm just telling you that by changing it to a January 1 start date, you've got enough money in the budget that if you decide that arbitrary number that I picked of 15 for the public defenders and the DAs should be 20 or 25, or you decide that number of 30 for the Superior Court judges should be 35, I want this bill to pass the House and the Senate, so I don't want to do anything that's going to jeopardize it. But if you are of the opinion that it should be 35 rather than 30, or 20 or 25 rather than 15, you've got the money, in my opinion, in the budget because of the start date to do that. And having said that, I hope that doesn't generate any more questions.
I see none. Thank you. We'll entertain the bill in just a moment. Is there any? I would like to have, I know that Mr. Spahas wanted to make a comment. I'd like to limit. We've had a long series of discuss. Please come up. I'm sorry I didn't have a sign-up sheet, but this works fine.
Kathy Goslin, I'm with the Council of Superior Court Judges. I spoke last time we were here. I'll be very brief.
Welcome, Judge.
Thank you. It is our opinion that all the Superior Court judges should receive an increase in the state-based pay because it has not been increased in 16 years. However, we are not going to stand in the way of some of our judges receiving a raise. We do have reservations, and those were already mentioned by the sponsor. We continue to have those reservations about the complexity of the retirement system issues and the disparity there will be in the retirement system, as well as constitutional issues. But, as I said, we will not stand in the way of some of our judges receiving a raise.
Well, thank you, Judge, and the Chair wishes to thank you personally because you've worked tirelessly on this, and I think your members should recognize that. Thank you. Anyone else wish to testify? Seeing none, I now call for a motion. Do I have a second? All in favor say aye. All opposed, like sign. It passes. Congratulations. We have two other bills for consideration, but only for consideration and not a vote today, just for the simple fact of getting the sense of the committee and any questions the committee might have. And Chair calls Representative Fleming on House Bill 458.
Thank you, Mr. Chairman, and members of the committee. I appreciate you.
Let's see, let me do that. There we go. And it's Chairman Powell.
Thank you, Mr. Chairman. I've got some concerns with this because of some legislation we've had in past years. Back several years ago, we had a proposition in front of us from what basically being a legislator was a citizen legislator. And there's a substantial amount of difference in the salary structure between judges and the legislators. And what we're wanting to do by this proposition is start treating them as a different category. Not only are they as a full-time salary in their profession, but then we're wanting to go ahead and open this up. But don't you think this could very well open up a lot of barn doors that we really don't want to get opened up?
I thought about that, Mr. Chairman, and I started trying to analyze how many folks can be elected statewide but live away from here. And you are right, the PSC, I remember that debate, and I actually was for that. I thought it was, I didn't want to, they have to live in districts, I believe. I thought it wasn't a bad idea to allow that for them even then, but there's just so few statewide elected officials that this would fall into. And but it is a valid question. I agree with you, and this may start somewhere, but even if it ballooned into everybody that's elected statewide, we're only talking about a handful of people, relatively speaking. Far less than even members of the Senate.
I guess my concern is that if we open this up for members of the judiciary, then we open it up for virtually any and all statewide elected officials. And I don't know if that's something that we're wanting to go with, because these folks are already on a statewide, they're on a full-time salary.
I see your point, and I think you're right. The only thing I would say to you that even if it did get blown completely open to everybody who was a statewide official, the group is so very small. We're talking about a very select, small section of folks. And of course, we'd have to pass legislation, so we'd have to decide to do that on a case-by-case basis. Someone would have to introduce it and bring it forward.
Thank you, Mr. Chairman. Any other questions from any member of the committee? Representative Coomer.
Just one other thought you might keep in mind as you're going forward. I know from time to time the courts will hold session somewhere other than at the Judicial Building in Atlanta.
Yes, sir.
And I don't know what you'd want to make in terms of provision for that.
In my files, it's an expense of the court, and the hotel rooms and all that they get are probably provided for them. But that is a good question. I've written that down as number two.
So to that point, you wouldn't want somebody to collect per diem who lived 100 miles from the Judicial Building. If court's being held in Augusta and they live in Augusta, you wouldn't want to create a situation where there'd be, I hate to use the term double dipping because it has a negative connotation, obviously, but I don't think our judges would do that, but we don't want to put it in code that way.
I see your point. I'll figure that one out too. Thank you.
Thank you, Representative Coomer. Any other questions from any member of the committee? Hearing none, thank you for your work. We'll be discussing this later on.
Thank you, Mr. Chairman. I appreciate that. If I may be excused, I need to go back to chair another committee.
You may.
Thank you.
The next bill is House Bill 236. That is, I have to sponsor the bill. We're not going to call it for a vote. We are going to call it for discussion, and I would like members of the committee to be open and honest about it. I do have Mr. Thomas Worthy, Ms. Russ Sewell, they're going to be testifying to this bill, and I'd love to hear what they have to say. But this bill is essentially called the Attorneys for Rural Areas Assistance Act. It's my understanding that in the state of Georgia, there are 6 counties that currently have no attorneys and several counties that have less than 6. This was brought to my attention by the State Bar of Georgia, and we're looking to increase the number of attorneys and improve access to justice in those underserved areas of rural Georgia. We're looking to, for those attorneys, young attorneys that will come and spend time in those areas and work in those areas, to be able to give them a grant to have help to pay off their student loans, similar to what we did with the doctors and the rural doctors. This would be managed by the Department of Community Affairs, and with that, and I can certainly go into more detail, but I'd like to ask Ms. Worth to come up, please.
Individuals that need to conduct legal affairs, and we have found through studies at the State Bar that in counties where reasonable access to attorneys are not available, justice is delayed and sometimes justice is flat out denied. So as you mentioned, Mr. Chairman, this is directly mirrored off of the rural physicians program that the General Assembly passed about 10 years ago. This would be managed by the Department of Community Affairs. With their expertise in the rural development area, they would be the ones that promulgated rules and regs to determine what areas of the state are underserved. They would also promulgate the rules and regs as to what attorneys are qualified for this program. However, as you mentioned, this would provide 5 years worth of loan repayment up to the average of an in-state law school. And with that, I'll answer any questions that the committee may have.
And it's my understanding it would not exceed $1,000 a month to pay up.
Correct.
Their own. Okay. With that, any questions from the committee? Hearing none. And thank you. We're going to be sitting down, having some more discussions on this later on, but I at least wanted to bring it to the attention of committee. I would ask the committee to give me their good thoughts, because I certainly want to hear them. As we've discussed among ourselves, and for any future legislation that this committee might see, I'm very fortunate as a chairman to have some truly outstanding people, and I value each of their opinions. And also, I failed to, on Chairman Jay Powell's bill, I failed to thank the study committee for their good work, and I appreciate that. Mr. Worth, thank you very much. With that, we are adjourned.